Hello friends, today's topic is BEPS Action Plan 6, which is preventing treaty abuse, or treaty abuse is another word for treaty shopping, wherein we will understand what is treaty abuse or treaty shopping, what are the corresponding OECD guidelines therein, OECD recommendations, and what are the India tax provisions relating to BEPS Action Plan 6. So friends, BEPS Action Plan number 6, which is related to preventing treaty abuse. In this action plan, first let's try to understand what is the meaning of treaty abuse. This example has been discussed earlier also, wherein a simple transaction, a plain vanilla transaction is between A and B. A is investing in B, A is holding company, B is subsidiary company. Now, the MNC company, this both entities A and B are part of main parent holding company, which is, you can say, ABC Limited, right? So plain vanilla transaction was between A and B, A being a holding company, B being a subsidiary company. However, there is a treaty benefit available where investment is done by C Limited, where investment is done from C Limited in B Limited, wherein there is a favorable treaty benefit available between country C and country B. So instead of investing from country A to country B, what the ultimate parent holding company ABC Limited did was they have routed funds through country C, and ultimately it has been invested in country B. Only because the investment was routed, only because there were benefit available where investment has been done from country C into country B. So you can say that a transaction has been structured in such a way only to obtain benefit under a treaty, only to obtain a treaty benefit. And this is another term for treaty shopping, or you can say treaty abuse, wherein you are doing this, everything has been done legally, but this transaction has been structured in such a way that maximum benefit can be obtained by the MNC company. This generally result in a lower tax rate or nil tax rate, which ultimately benefits the MNC company and which is against a normal competition, or which leads to effects of BEPS. So in order to prevent such type of treaty abuse wherein transactions are structured only to obtain a treaty benefit between country to country, and such treaty benefit will be available country to country. It may be between A to C, B to C, or between India, Mauritius, India, Singapore, India, US. So benefit will be available from treaty to treaty, and companies, instead of opting for plain vanilla transaction, they are going for a structured transaction, and the only intention behind that is to obtain treaty benefit. And if such an intention has been proved, if such an intention is proved wherein transactions are structured only to obtain treaty benefit, then BEPS Action Plan recommends that this will be disallowed straightforward, wherein such a type of benefit won't be allowed to a company, and accordingly domestic tax provisions will apply. So friends, Here the domestic tax provisions will apply in a way the treaty benefit won't be available. Meaning, whenever there is a transaction between A and B, then whenever there are cross-border transactions, there is always a possibility of either you go to treaty or you consider domestic tax provisions, whichever is more beneficial as per section 90-91, SSC adopts that. Similarly, if in the case of cross-border transactions which are related to treaty abuse, then the SSC won't have an option to take treaty benefit. The only option left would be to adhere to the domestic tax provisions of the respective country. Fine. So, coming back to, after we have understood what is preventing treaty abuse or what is treaty shopping, now let us understand what is Action Plan 6 and what are the OECD guidelines. Action Plan 6 is a minimum standard. It is a mandatory standard which has to be adopted by the OECD member countries only because it provides protection from treaty shopping, and this is one of the main agendas of tackling with BEPS. Accordingly, this is the minimum standard that OECD members has to adopt, wherein you have to implement measures for preventing treaty abuse. It could be either in the domestic tax provisions or this recommendations should be adopted in the existing treaty. And any changes in the existing treaty, it could be either through deciding on the protocol I mean through negotiations between the treaty partners. A protocol is finalized which will amend the existing articles of the treaty, or either it can be through MLI, multilateral instrument, which is part of action plan, which is one of the part of action plan of BEPS. Action plan number 15, multilateral instrument. Through multilateral instrument also treaties can be modified. And there will be several terms in it in the action plan number 6 which you will come across. It is PPT, LOB. So PPT is principal purpose test, wherein this concept is similar to GAR provisions, general anti-avoidance rules. The meaning of principal purpose test is, in an example that we took, wherein instead of country A investing in country B, the transaction is structured as if country C is investing in country B. So here, principal purpose of the transaction is to obtain treaty benefit. Accordingly, through PPT, principal purpose test, if the principal purpose is to obtain treaty benefit, then benefit will be denied to the SSC. This is what is principal purpose test. If principal purpose test as per PPT, if as per PPT main intention was to obtain treaty benefit, then treaty benefit will no more be available to the SSC on that particular transaction. If as per PPT test there is no such intention and this is a normal transaction that an SSC could have entered, then the treaty benefit will be and shall be available to the SSC. Similarly, LOB, limitation of benefits. Here, the benefit will flow to the SSC, will be available to the treaty partners. However, there will be a certain limit which will be mentioned in the respective article. So, benefit won't be available 100%. There will be a certain limit on availing the benefit, there will be certain conditions on availing such a benefit. So friends, on your screen, Action Plan 6, Preventing Treaty Abuse, Protection Against Treaty Shopping, and it's a minimum standard, mandatory standard as per BEPS. Express statement in a tax treaty. OECD has recommended express statement in a tax treaty that common intention is to eliminate double taxation. The common intention is to eliminate double taxation without creating opportunities of non-taxation or reduced taxation through tax evasion or avoidance, including through treaty including through treaty shopping arrangements. So, as per OECD recommendations, an express statement should be made in the tax treaty itself, wherein the common intention is to avoid double taxation without creating opportunity for non-taxation or reduced taxation, including treaty shopping arrangements. Countries will implement this common intention, which has been mentioned in bullet number 2. Countries will implement this common intention by including in their treaties combined approach of LOB, PPT, principle, purpose, test, and limitation of benefits rule, or PPT rule alone, or LOB rule supplemented by a mechanism that would deal with conduit financial arrangements not already dealt within tax treaties. So either you take LOB rule, either you take PPT rule or LOB rule, and LOB rule should be supplemented by an additional arrangement, right? And here conduit means shell companies, or in our example, the company which has been the company which has been established in country C will be a shell company, conduit company. So LOB rules should be supplemented by a mechanism which is mentioned in Action Plan 6. PPT rule alone is also fine, or you take a combined approach of LOB and PPT. So the common intention, which is eliminate double taxation and non-taxation as well, and it can be achieved through PPT rule, LOB rule. Implementation and through the peer review board, where an intention, whether through the peer review board, when there was a review process going on by OECD on the member countries, whether indeed they have implemented these provisions or not. When they checked it, they came to understand that most of the countries have already implemented this minimum standard in their respective treaty or in the domestic tax provisions. Also, as per peer review report and as stated by OECD as well, multilateral instrument MLI will prove to be very much handy in implementing Action Plan number 6, Preventing Treaty Abuse, as well as other minimum standards in the existing treaties in place. So on your screen, implementation, peer review findings, large majority of inclusive framework members have begun to translate their commitment on treaty shopping into actions. So review or findings of peer review were positive. The first peer review shows the efficiency of MLI, which is Action Plan number 15, efficiency of MLI in implementing the minimum standard, MLI in implementing the minimum standard and other treaty related BEPS measures. As per OECD, it is by far the preferred tool of the member countries for implementing the minimum standard. So some positive notes on MLI and positive notes on implementation of the commitment by the member countries has been stated in last two bullet points. So friends, beginning with India chapter, the India tax provisions, what has been implemented or what actions have been taken by India against treaty shopping, against treaty abuse. First was LOB, introduction of limitation of benefit rule in India-Mauritius tax treaty. Just to give you background, what was happening earlier was two companies, you can say, India and Mauritius. Mauritius has made investment in India, and at the time of sale of shares of Indian company, capital gains ideally should have been taxable in India as per domestic tax provisions. If we see, capital gains will be taxable either as long term, short term. However, as per India Mauritius treaty, if a company who is resident in Mauritius has capital gains income from selling of Indian shares, then in such a case, no capital gains will be taxable in the hands of Mauritius company. So, straightforward, there was a benefit in the hands of Mauritius company, wherein if they sell their shares, if they are exiting from an Indian company or even a part exit, partly if shares are sold, they have capital gains income. Such gains were not subject to tax at all because treaty benefit was available. He will consider he will consider domestic tax provision and treaty provisions, whichever is more beneficial to the SSC, and treaty provisions were more beneficial for the Mauritius company, wherein no gains were taxable at all. This was before introduction of LOB rule, which is limitation of benefit rule. So earlier the benefit was 100% to the Mauritius company. Now after introduction of LOB rule, and this change was brought in by signing a protocol, by signature of protocol between India and Mauritius. So as we had discussed earlier, changes in existing tax treaty can be done by way of protocol, and now changes can be done by way of MLI, multilateral instrument. So this change was made from previous year 1718, wherein a protocol was signed in May 2016, wherein both the treaty partners, India and Mauritius, agreed to tax the capital gains in the hands of Mauritius company for initial two previous years, which is from 1st of April 2017 to 31st of March 2019. So two previous years are involved, 17-18 previous year and previous year 18-19. For these two previous years, if you have any capital gains income in these two previous years, if you have any capital gains income, then the same will be taxed at 50% of the rate mentioned under the treaty. So whatever is your capital gains, it will be divided by 50. So you can say there is limitation in benefit. Benefit is provided. However, benefit has been restricted. There is a cap on benefit and it is 50%. And obviously, for the period where the shares have been acquired and sold before, and the period for which the shares have been purchased. So the previous year that we are concerned is 1st April 17 to 31st of March 2019, and thereafter from 31st of March 2019 the tax rate will be normally applied between the entities, wherein this 50% benefit also will be removed. On your screen, LOB clause introduced in India-Mauritius Tax Treaty on 10th of May 2016 by signing of the protocol. Taxability of gains from alienation of shares acquired on or after 1st of April 2017 in a company which is a resident of India. So shares should have been acquired on or after 1st of April 2017, and obviously you should have capital gains during the previous year 17-18 and 18-19. So the period which the protocol is talking about is acquisition after 1st of April 2017. If you have acquired shares before 1st of April 2017, then this protocol won't apply. Then you will continue to be eligible for 100% benefit. The term used therein is the term used for such investments which are acquired before 1st April 2017 is grandfathered. Grandfathered meaning if acquisition was made before 1st of April 2017, then the benefit of India-Mauritius Treaty of nil taxation rate will continue to apply, and the provisions are called grandfathered. And in a way, they are trying to say that these provisions won't apply retrospectively. The provisions will apply prospectively from 1st of April 2017. Two financial year periods, 1st of April 17 to 31st of March 2019. Tax rate not to exceed 15%, not to exceed 50% of the tax rate applicable on such capital gains in India. So for two previous years, there was certain limitation of benefits. LOB clause has been introduced, which provides that a resident of a contracting state means resident of Mauritius, shall not be entitled to the benefits of 50% of the tax rate applicable in transition period if its affairs are arranged with the primary purpose of taking advantage of concessional rate of tax. So here, bullet number 4 is talking about principal purpose test, wherein if the principal purpose of the transaction is to obtain treaty benefit, if the Mauritius company is investing in India only to obtain treaty benefit in this case is nil rate of capital gains taxability. And in our example that we gave at the start of this discussion was between A, B and C, wherein instead A Limited directly investing in B Limited, they are going through C Limited, wherein A Limited is investing in C Limited and then C Limited is investing in B Limited. And for example, if C Limited is in Mauritius, then this provision bullet number 4 cut start, then bullet number 4 will apply to the country, to the company which is in Mauritius, which is C Limited in our example. And in that case, the benefit of 50% rate for the financial year for the previous year 17-18 and 18-19, the beneficial rate of divided by 2, which is 50% rate, will not be eligible to C Limited, wherein through PPT rule, through PPT test, it has been concluded that principal purpose of C Limited was to obtain treaty benefit, and accordingly you will no more be eligible for any treaty benefit, and accordingly domestic tax provisions will apply. And this is what bullet number 4 is trying to say. I will again read this. LOB clause has been introduced which provides that a resident of Mauritius shall not be entitled to the benefits of 50% of the tax rate applicable in the transition period. Transition period is previous year 1718 and 1819 if its affairs are arranged with the principal purpose of taking advantage of concessional tax rate. So, in the principal purpose test, it has been concluded over here. If it is concluded that the transaction is structured in such a way, the transaction is structured only to obtain treaty benefit. Here, C Limited will be a shell company or conduit company. A shell or a conduit company claiming to be a resident of Mauritius shall not be entitled to this benefit. Shell company meaning is any legal entity falling within the meaning of resident with negligible or nil business operations, or with no real and continuous business activities carried out in contracting state. In our example, it is Mauritius. So shell company is that which, if you see as a larger picture, that normal business activities are not carried out at all, and that company, such company will be termed as shell company or conduit company. And in our example, it will be C Limited, which will be held to be a shell company, and accordingly the treaty benefit won't be available to such companies. Such company will be deemed to be a shell or conduit company if its expenditure on operations in that contracting state, which is Mauritius, is less than 7 lakhs in the immediately preceding period of 12 months from the date of the gains arise. So let's take an example. If in our example C Limited had carried out certain activities, certain limited activities, so it won't fall in bullet number 2 over here, meaning certain business activities were carried on by such a company, by C Limited. So it won't fall in a shell company. However, where the activity is less than 7 lakhs, in the immediately preceding year for a period of 12 months, in the immediately preceding year, if the activity is less than 7 lakhs, then such a company will be deemed to be a shell or conduit company. Meaning, before the capital gains arise, what C Limited did was they carried out certain activities just to ensure that they do not fall under the definition of shell company. However, as per the second last bullet point, which is deemed to be shell conduit company, however, the activities carried out by C Limited were less than 7 lakhs. The expenditure was less than 7 lakhs. In such a case, C Limited will be deemed to be a shell company, and accordingly treaty benefits won't be available. So friends, LOB clause in India-Mauritius tax treaty. In this we have studied that the previous period before 1st of April 2017, capital gains arising from alienation of shares or from selling of shares of an Indian company by a company in Mauritius, capital gains rate was nil, exempt, nothing was taxable in the hands of Mauritius company. But after the introduction of LOB clause, which is as per BEPS Action Plan number 6, preventing treaty abuse, after the introduction of LOB clause in the India-Mauritius Treaty for 2 years, from 1st of April 17 to 31st of March 2019, if you have acquired shares on or after 1st of April 2017, then capital gains income, if any, will be taxable at 50% of the applicable rate, meaning there was limitation of benefits, and even this 50% of the applicable rate was denied to a shell company, conduit company, whose intention was only to obtain treaty benefit, whose principal purpose was to obtain treaty benefit. Similarly, such an LOB clause has been introduced in India-Singapore Tax Treaty as well, and the terms and conditions are similar to India-Mauritius Tax Treaty. So, in both the cases, LOB clause has been introduced by way of protocol in India-Mauritius Treaty, in India-Singapore Treaty, and the loophole which has been plugged is no more the capital gains benefit will be available to the companies which are in Mauritius, Singapore respectively. So this was India related measures as per in line with BEPS Action Plan number 6, which is related to preventing treaty abuse, treaty shopping, and is one of the minimum standards of the BEPS Action Plan. So this concludes Action Plan number 6, which is preventing treaty abuse. Thank you.